No humans were harmed or even used in the creation of this program. We created it from a script written by the presenter using a generative artificial intelligence platform. We hope you enjoy it. Welcome to today's program, Multi-Jurisdictional Practice While Avoiding the Unauthorized Practice of Law. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I am speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Several years ago, the National Law Journal published an expose entitled "GCs Forget One Detail, Their License," where they famously outed 8 general counsels of Fortune 500 companies who were not properly licensed to practice law in the states where they worked. If the journal were to run a similar story today, might your name be on that list? Of course, that would be a reputational disaster and something I am sure each of you very much would like to avoid. I'm here today to talk to you about how lawyers should approach practicing law in states where you are not licensed, and to share 4 key pieces of advice that should help you to avoid engaging in the unauthorized practice of law. Throughout my career, both as a law firm and in-house lawyer, I frequently have been asked to advise clients and work on matters arising throughout the United States, not just in New York and California, where I am a member of the bar, but in states like Nevada, Texas, and Virginia, among many others. As a result, the issues raised by multi-jurisdictional practice are ones I have researched and thought a lot about in my legal practice. Even if most of the legal work you do for your law firm or company is for clients in your home state, in today's world, chances are you're going to be asked to work on transactional or litigation matters arising in other states. For that reason, it's important to know the rules that govern multi-jurisdictional practice and the unauthorized practice of law to make sure you always stay on the right side and never the wrong side of those rules, because breaking them can have serious consequences for lawyers. The good news is that the rules that govern multi-jurisdictional practice are now much clearer and easier for lawyers to navigate than at any time in the past. If you spend an hour with me today to learn the rules and take care to follow them, you should be able to represent your clients in matters arising in any U.S. state, confident that your name will not appear on a future wall of shame of lawyers engaged in the unauthorized practice of law. We're going to do a couple of things today. First, we're going to talk about the legal ethics rules in some detail, which are ABA Model Rules 5.5 and 8.5. In case you're worried that studying ABA Model Rules might be a waste of time, I am pleased to inform you that as of September 2024, ABA Model Rules 5.5 and 8.5 have been adopted in some form or another by 48 of the 50 U.S. states plus the District of Columbia. So this means that if you live in any state except Hawaii and Texas, and if you learn ABA Model Rules 5.5 and 8.5, you'll be pretty well covered, which is great news for today's lawyers. I would be remiss if I didn't pause briefly to contrast today's regime of nearly uniform rules with 25 years ago, when we had substantial uncertainty over what, if any, legal practice outside your home state was permissible. While the ABA doesn't always get things right or make the practice of law less complicated, we should credit them in this case for promulgating amendments to ABA Model Rules 5.5 and 8.5 and persuading nearly all states to adopt them in some form. Second, even though both California and New York are among the states that have adopted rules similar to ABA Model Rules 5.5 and 8.5, we are going to spend some time reviewing the rules in those states in detail for 2 reasons. First, many lawyers, like me, are licensed to practice in one or more of those 2 states, so it will benefit a lot of lawyers to know the specifics of those rules and what they require of lawyers who are governed by them. Second, pursuant to the terms of ABA Model Rule 8.5, a lawyer is not only subject to the legal ethics rules of the state in which he or she is licensed, but also in any state where the lawyer provides or offers to provide legal services. Because law firm and in-house lawyers often work on transactional or litigation matters arising in California or New York, Those lawyers need to know the legal ethics rules that govern the practice of law in California and New York under those states' equivalents of ABA Model Rule 8.5. Third, we are going to cover off the question of remote or hybrid work. Helpfully, in recent years, the ABA, as well as California, New York, and many other states, have interpreted ABA Model Rule 5.5 to permit lawyers who have chosen to continue working on a fully remote or hybrid basis following the COVID-19 pandemic to do so without having to worry that they are engaging in the unauthorized practice of law, as long as they follow a few simple rules. Along the way, I'm going to share 4 key pieces of easy-to-follow advice for lawyers that should help you avoid engaging in the unauthorized practice of law. Before we get started, why should you care about multi-jurisdictional practice? After all, what's the worst that could happen to a lawyer who is found to have engaged in the unauthorized practice of law? Well, the parade of horribles is actually quite long and distinguished, and it includes at least 4 categories of nasty consequences: reputational, financial, legal, and ethical. We already talked about reputational consequences. Being outed publicly as an unlicensed lawyer would be a very bad thing for you and your law firm or company. We shouldn't underestimate it, but we don't need to belabor the point either. Financial consequences could include potential loss of attorney's fees to which you otherwise would be entitled, and damages arising from potential malpractice claims by unhappy clients. The legal consequences for the unauthorized practice of law include civil liability for you and your law firm or company for violating unauthorized practice of law statutes. A finding of unauthorized practice of law also means that your law firm or company could lose the protection of the attorney-client privilege with respect to communications between you and your clients, and the protections generally accorded to your litigation work product. In the view of the courts that have considered these cases, the result is binary. Either you are a lawyer properly licensed to practice in the state, in which case the attorney-client privilege attaches to your communications with your client and to your litigation work product, or you are not a lawyer properly licensed to practice in the state, in which case there is no privilege or work product protection. No middle ground exists for cases where the client or the lawyer made a mistake of fact or law about the lawyer's right to practice law in the state. It's all or nothing. I'm sure you can imagine how unhappy your clients would be if you had to disclose internal communications everyone thought were privileged, or litigation memoranda everyone believed were protected as work product. Finally, there are the legal ethics consequences for you as a lawyer for having engaged in the unauthorized practice of law, which include potential state bar sanctions of a fine, suspension, and disbarment. As we will see later, in nearly all states, a lawyer now can be subject to discipline in at least 2 states: the state where he or she is licensed and any of the states where he or she performed legal work. So the potential sanctions are effectively multiplied by the number of states involved. Whichever of these awful consequences you most want to avoid, reputational, legal, or ethical, you simply do not want to be on the wrong side of an unauthorized practice of law finding. Over the next hour, I'll give you the information and guidance you need to avoid that unhappy result, starting with a little background. In 2000, the ABA formed a multi-jurisdictional practice commission to study the issues raised by lawyers practicing law in states where they are not admitted, and just 2 years later, in 2002, the Commission's report and recommendations, which included amendments to ABA Model Rules 5.5 and 8.5, were adopted by the ABA. As I mentioned, as of today, every state except Hawaii and Texas, as well as the District of Columbia, have adopted these amendments to ABA Model Rules 5.5 and 8.5, or similar rules. Let's take a look at what these rules provide, starting with ABA Model Rule 5.5. This is a long rule, but it's critically important for our topic today, so we need to review it in its entirety. We'll break it down into sections a bit later, so don't worry if you find the full text of the rule hard to follow. ABA Model Rule 5.5, which is entitled Unauthorized Practice of Law, Multi-Jurisdictional Practice of Law, provides as follows. A lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. B, A lawyer who is not admitted to practice in this jurisdiction shall not: 1. Except as authorized by these rules or other law, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law; or 2. Hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. C. A lawyer admitted in another United States jurisdiction and not disbarred or suspended from practice in any jurisdiction may provide legal services on a temporary basis in this jurisdiction that: 1. Are undertaken in association with a lawyer who is admitted to practice in this jurisdiction and who actively participates in the matter; 2. Are in or reasonably related to a pending or potential proceeding before a tribunal in this or another jurisdiction, if the lawyer, or a person the lawyer is assisting, is authorized by law or order to appear in such proceeding or reasonably expects to be so authorized. 3. Are in or reasonably related to a pending or potential arbitration, mediation, or other alternative resolution proceeding in this or another jurisdiction, if the services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice and are not services for which the forum requires pro hac vice admission; or 4. Are not within paragraphs C2 or C3 and arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice. D. A lawyer admitted in another United States jurisdiction or in a foreign jurisdiction and not disbarred or suspended from practice in any jurisdiction or the equivalent thereof, or a person otherwise lawfully practicing as an in-house counsel under the laws of a foreign jurisdiction, may provide legal services through an office or other systematic and continuous presence in this jurisdiction that: 1. Are provided to the lawyer's employer or its organizational affiliates, are not services for which the forum requires pro hac vice admission, and when performed by a foreign lawyer and requires advice on the law of this or another U.S. jurisdiction or of the United States, such advice shall be based upon the advice of a lawyer who is duly licensed and authorized by the jurisdiction to provide such advice; or 2. Are services that the lawyer is authorized by federal or other law or rule to provide in this jurisdiction. E. For purposes of paragraph D. 1. The foreign lawyer must be a member in good standing of a recognized legal profession in a foreign jurisdiction, the members of which are admitted to practice as lawyers or counselors at law, or the equivalent, and subject to effective regulation and discipline by a duly constituted professional body or a public authority; or 2. The person otherwise lawfully practicing as an in-house counsel under the laws of a foreign jurisdiction must be authorized to practice under this rule by, in the exercise of its discretion, the highest court of this jurisdiction. Before we get into the specifics, it's important to recognize what a step forward the amendments to ABA Model Rule 5.5 was when it was first adopted by the ABA and later by the individual states. For the first time in American legal practice, you have a rule that affirmatively allowed a lawyer to practice law on a temporary basis in a state where he or she is not admitted. Prior to ABA Model Rule 5.5c, there was no such authority and all such law practice was undertaken at the lawyer's risk. This was a huge step forward for lawyers and our clients, and we should thank the ABA for driving this change. Now, ABA Model Rule 5.5 does not give lawyers carte blanche to practice law outside their home states, even on a temporary basis, and you should think about the public policies behind the unauthorized practice of law statutes as the main reasons why. These policies were in part a desire to ensure that clients in a state received competent representation, and in part a desire to protect lawyers in that state from competition from lawyers in other states. You can have a healthy debate about whether the desire to protect in-state clients and/or in-state lawyers remain valid objectives in today's world, but the fact that those concerns still exist explains why neither the ABA nor the individual states who have adopted ABA Model Rule 5.5 were willing to go further than they did in authorizing lawyers to practice across state lines. So the result is that a lawyer's ability to practice outside his or her home state on a temporary basis is limited to 4 specific categories that are set out in ABA Model Rule 5.5C 1-4. Importantly, this is not true of remote or hybrid work, which is not considered temporary because lawyers generally are engaging in remote or hybrid work on a permanent basis. And we will talk about remote or hybrid work as a separate topic later in today's program. The first category in ABA Model Rule 5.5C1 is when the out-of-state lawyer associates with a lawyer in the state who actively participates in the matter. This category is available to both transactional lawyers and litigators, and it gives out-of-state lawyers the ability to perform legal services for in-state clients as long as an in-state lawyer is representing the client as well and is playing an active role in the transaction or litigation matter. For in-house lawyers, ABA Model Rule 5.5C1 would require you to have another in-house lawyer at your company who is a member of the bar of that state associate with you, which often is not possible, or to hire outside counsel in that state to represent your company in the matter so you can associate with those lawyers, which is costly and can be inefficient, particularly if you are already represented by outside counsel in the same matter in another state. If you are cynical, the option for out-of-state lawyers to associate with in-state lawyers sounds like a better deal for both sets of lawyers than the client. The second category in ABA Model Rule 5.5C2 is limited to litigators, and it allows representation of a client in this state if the representation relates to a matter in this state in which the lawyer is authorized to appear, that is, admitted to that court's bar, or admitted for that matter pro hac vice, or to a matter in another state in which the lawyer is authorized to appear, that is, admitted to that court's bar or admitted for that matter pro hac vice. By way of example, if you are a California lawyer and you want to represent a Nevada client who has been sued in state court in California, you can do that under this category as long as you are admitted to practice in the California State Court. Similarly, if you are a California lawyer and you want to represent a Nevada client who has been sued in state court in Nevada, you can do that under this category as long as you are admitted to practice in the Nevada State Court, which admission would be pro hac vice because you are not a member of the Nevada bar. While it's nice to have this rule, it really only serves to confirm that litigators who are admitted to practice in the court of their state can represent out-of-state clients in those matters, and conversely, that litigators who are admitted pro hac vice in the courts of other states can represent out-of-state clients in those matters. It doesn't give litigators the right to practice law outside their home state, except when it is related to a specific litigation matter pending before a court in which they are admitted to practice. The third category in ABA Model Rule 5.5C3 is also limited for the most part to litigators because it allows representation of a client in this state if the representation relates to a pending or potential mediation, arbitration, or other form of alternative dispute resolution located in this state or in your state. In order to take advantage of this provision, the mediation, arbitration, or other ADR process must relate to the services the lawyer is already doing in his or her state. So, if you are a New York lawyer representing a California client, performing legal work for the client in connection with a dispute arising in New York, you can appear and participate in a AAA arbitration to be held in California without committing the unauthorized practice of law in California under the authority of California's version of ABA Model Rule 5.5, which is California Rule of Court 9.43 and is similar to ABA Model Rule 5.5. ABA Model Rule 5.5C3 thus specifically authorizes out-of-state lawyers to participate in mediations and arbitrations held in a state where they are not admitted on behalf of clients in that state. Of course, this leave to participate in a mediation or arbitration is not unlimited either under ABA Model Rule 5.5C3 itself, which places two very important limits on it, or under the similar rules adopted by states like California that may contain other limits or requirements. The first limit set out in ABA Model Rule 5.5C3 is that the mediation or arbitration must be related to services you are performing for the client in your state. If you are not performing any services for the client in your state, then you are not allowed to take advantage of this provision. The intent here is to prevent litigators from being brought in solely to participate in a mediation or arbitration where they have had no prior involvement with the client or dispute, that is, a hired gun, solely to handle the mediation or arbitration. By contrast, the intent is to allow out-of-state lawyers who have been involved in the dispute from the get-go to continue to be involved as that dispute gets resolved through mediation and/or arbitration. For in-house lawyers, of course you are already providing services to your company in connection with the matter in your home state, so this requirement always would be satisfied. The second limitation in ABA Model Rule 5.5c3 is that the out-of-state lawyer can participate in a mediation or arbitration unless pro hac vice admission is required to appear in the mediation or arbitration. There are a few possibilities here. If the mediation or arbitration is being conducted by order of a court or pursuant to a judicial referral, it's likely that the rules of that court will require lawyers to be admitted to practice in that court before they can participate in the court-ordered mediation or arbitration. Pursuant to ABA Model Rule 5.5c3, you'll need to determine if your court requires pro hac vice admission in such circumstances, and if it does, secure that admission before participating in the mediation or arbitration. If the mediation or arbitration is being conducted pursuant to the agreement of the parties, either in a pre-existing contract or an agreement made after a dispute arose, and not by order of a court, then it's possible nothing more is required of a lawyer in order to participate. That is the case in New York, where a lawyer can participate in a mediation or arbitration held in New York without any further limitations or requirements pursuant to New York's version of ABA Model Rule 5.5, which is New York Rule of Court Section 523, and is similar to ABA Model Rule 5.5. That is not the case in California, which imposes some additional limitations and requirements on lawyers participating in mediations or arbitrations beyond what is set forth in ABA Model Rule 5.5. First, under California Rule of Court 9.43, the out-of-state attorney must apply to the arbitrator or arbitral forum for permission to appear and serve a copy of the application on all parties and the state bar. This notice requirement is similar to the notice requirement for seeking pro hac vice admission in California state courts. Helpfully, there is no express requirement that the lawyer associate with a member of the California bar, or that the out-of-state lawyer not be a resident or regularly practice in California to be allowed to appear before an arbitrator, which is different from the requirements for pro hac vice admission. Second, California Rule of Court 9.43 requires that the application to appear in the arbitration meet the standards of California Code of Civil Procedure, Section 1282.4, which in turn requires an application to include the name and address of local California admitted counsel who will be the attorney of record in the arbitration, and that the out-of-state lawyer's practice within California be only occasional. While these two additional requirements imposed by California on lawyers seeking to appear in mediations and arbitrations in California are pretty manageable, the fact that New York, which has no additional requirements beyond what is set out in ABA Model Rule 5.5c3, and California, which requires lawyers to jump through a few additional hoops, have differences, illustrates why it is important to check the specific rules of the states where you are not admitted and in which you plan to render legal services, even if those states have adopted rules similar to ABA Model Rule 5.5. The fourth category in ABA Model Rule 5.5c4 is for matters relating to or arising out of your practice in your state and not otherwise covered by the other categories. This category is intended to function as a catch-all of sorts to cover situations where you are working on a matter that's primarily related to your state, but it has effects in another state, and the matter doesn't fall squarely into one of the other categories we just mentioned because you're not associating with an in-state lawyer, it isn't a litigation matter or connected to a mediation or arbitration. This provision provides a safe harbor for lawyers who perform legal work for clients in states where they are not licensed, if the primary purpose of your representation of the client is related to your state and the representation of a client outside of the state where you are not licensed. So that's ABA Model Rule 5.5. While the rule is pretty clear, at least as far as ethics rules go, it did raise some questions that the ABA felt obliged to clarify in the commentary to the rule. The first question is whether prior representation of a client is necessary before a lawyer is allowed to practice law outside his or her home state on a temporary basis for that client. The answer to this question is no. The commentary to ABA Model Rule 5.5 makes it clear that prior representation of the client is not required, but it is one of the factors that is relevant to the requirement in Section C3, the arbitration rule, and Section C4, the catch-all rule, that the lawyer's services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted. So, if you have represented the client before in connection with matters in your state, that might serve to establish that your services are reasonably related to your practice in your state. Another factor is if the client has previous contacts with your state, or if the matter has a previous connection with your state and how many states are involved. That is it just your state and the new state, or are there multiple states involved that might weaken the connection to your state? In any case, the commentary makes it clear that while you can represent a new client for the first time in a state where you are not admitted if you are doing work for that client on a temporary basis, you are on safer ground if the client and/or the matter has some connection to your state in cases where you are relying on ABA Model Rule 5.5's arbitration or catch-all provisions to authorize your representation of that client. For in-house lawyers, you will have represented your company prior to the matter arising in the other state, and that matter will be reasonably related to your practice representing your company in your home state, so you should not have to worry about satisfying these requirements when taking advantage of the ABA model, Rule 5.5C sections 1 to 4. Let's walk through an example to illustrate how ABA model Rule 5.5 works in practice. Let's say you are a California lawyer who is employed as an in-house lawyer for a company based in California that has a factory located in Nevada and Arizona. Now a dispute has arisen with a Nevada vendor. Under ABA Model Rule 5.5C4, it generally would be okay for you to advise your company on Nevada law and Nevada dispute resolution in connection with trying to resolve the dispute with the vendor. Here, you have a California client, you have a history of prior representation of that client, and you have a lot of connection to California and not as much connection to Nevada. Before you actually participate in a mediation or arbitration in Nevada, you'd need to check to see whether Nevada requires pro hac vice admission or has other requirements for lawyers appearing in mediations or arbitrations in Nevada. Recall that California imposes some requirements while New York imposes none, to make sure you comply with Nevada's version of ABA Model Rule 5.5C3 if you are seeking to rely on the arbitration rule. Stepping back from the particulars of ABA Model Rule 5.5, it's easy to remember that, except in cases where you are associating with an in-state lawyer and where you are applying for admission pro hac vice in a litigation matter, the other categories of acceptable temporary legal practice in another state require some degree of connection between your client and/or the matter in your home state. The more connections you have, the fewer concerns you should have about performing legal work and providing legal advice, and vice versa. If you think about it, all of this is pretty sensible and should help guide you when you are analyzing these issues. The primary danger area here is that the commentary to ABA Model Rule 5.5 makes it clear that your practice of law is not temporary if you have systematic and continuous contacts with that other state, even if you are not physically present in that state, or if you hold yourself out as being admitted in that state. Let's say you are a New York lawyer working as an in-house lawyer for a company based in New York. You do most of your legal work on matters that arise in New York, and you provide legal advice to company officers, directors, and employees based in the company's New York headquarters. However, your company has a subsidiary based in California. From time to time, but with increasing frequency, you are asked to provide advice with respect to transactional and litigation matters that involve the subsidiary and other companies with which it does business in California. You also have provided legal advice to officers and employees of the subsidiary located in California in connection with their work for the subsidiary. You don't have a physical office in California, and we assume you never hold yourself out to anyone, whether to officers or employees of the subsidiary or to any representatives of any of the companies with which it does business, as a California lawyer, which of course would be a huge no-no. In addition, most of your clients, your company and its officers, directors, and employees are New York residents, all of which are helpful facts. But you still may have trouble claiming that you are only temporarily practicing law in California because you have systematic and continuous contacts with California, and you are routinely representing a California client, that is, the subsidiary. Nor does the mere fact that you are not physically located in California mean you can't have a systematic and continuous virtual presence in California. The commentary to ABA Model Rule 5.5 contemplates that a lawyer's presence can be virtual if he or she directs substantial communications to a state for the purpose of representing clients there, which, taken together, amount to a systematic and continuous presence in that state. What this very sensible part of ABA Model Rule 5.5 is saying is that if you are representing a state's clients on a systematic and continuous basis, you need to become a member of that state's bar, or need to register as an in-house counsel in that state, and can't rely on ABA Model Rule 5.5 to justify a law practice in that state that isn't in fact temporary. On the flip side, ABA Model Rule 5.5 recognizes that temporary law practice doesn't have a fixed time limit. We all know that litigations tend to last for many months and in many cases many years. The commentary to ABA Model Rule 5.5 confirms that you don't violate the requirement that your law practice in the other state be temporary simply because you continue to represent a client for a long period of time, for example, in a protracted litigation or in connection with a transaction that lasts for a year or longer. Now, if you repeatedly represent the same out-of-state client on one matter after another over a period of a dozen years, like the subsidiary company based in California we just discussed in our hypothetical, and neither the client nor any of the matters has any connection to your home state, that might be too much law practice in the other state to be temporary, and your representation may lack the required connection to your home state if you are relying on the arbitration or catch-all rules. In all cases, you need to be sensible about your representation of clients in states where you are not admitted, and think in each case whether your legal work is fairly considered temporary and sufficiently connected to your state. This brings us to the first of our 4 key pieces of advice for lawyers to help you avoid the unauthorized practice of law. When in doubt, register. While ABA Model Rule 5.5 probably covers you in most cases where you are performing legal work or providing legal advice on a temporary basis in matters arising in states where you are not licensed, you shouldn't rely on ABA Model Rule 5.5 to authorize your legal practice in states where you are physically located or are directing a substantial portion of your legal work on a regular basis. Thankfully, most states now allow in-house counsel to practice law in that state without sitting for the bar exam, requiring only that they satisfy certain requirements, register, and often pay some fees. Let's continue with California as our example, since my advice to the New York lawyer in our hypothetical who is regularly representing a California subsidiary would be to register as an in-house counsel in California. California requires in-house counsel to pay a fee of approximately $1,200 to register, and you must register within 6 months of your commencing legal work in California, otherwise your application might be denied. You also must pay about $500 per year to renew your registration, and complete 25 hours of CLE in the first year, and 25 hours every 3 years thereafter. While no one likes to pay fees, many companies will reimburse in-house lawyers for those fees, and while almost no one likes to fulfill CLE requirements, these days most CLE programs are available online and approved for credit in multiple jurisdictions, so the same CLE programs you watch to satisfy CLE requirements in your home state also satisfy the CLE requirement in California and other states. Is that really all I need to do in order to register as an in-house counsel in California and other states? As we lawyers also like to say, yes, but check the footnotes. California Rule of Court 9.46, which governs the registration of in-house counsel, imposes a few additional requirements, none of which is particularly onerous. For an out-of-state lawyer to practice in California as a registered in-house counsel, you have to be a member in good standing of your state's bar. This is all about allowing attorneys who are bar members in good standing in one state to practice law in another state, but you can't get anywhere if you're not already admitted and in good standing in your home state. You also must pass a character examination by the California State Bar, and as I mentioned before, fulfill CLE requirements and pay some fees to the California State Bar. Some of you might be thinking to yourself, he says when in doubt register, and that registration is easy, but if I add up all these requirements, wouldn't I have to do everything a California lawyer has to do except pass the bar exam? As we lawyers never like to say yes, period, but not having to take the bar exam in California is a huge dispensation. California has a notoriously difficult bar exam. The list of famous lawyers who have failed it include Vice President Kamala Harris, California Governor Jerry Brown, and the former Dean of Stanford Law School Kathleen Sullivan. So the only thing worse than taking it is taking it and failing it, particularly for an experienced lawyer who doesn't have the excuse of just having graduated from law school. As someone who took both the New York and California bars, I can tell you from personal experience that taking the California bar was much worse, not because it is a harder test, New York's was harder by far, but because the pass rate in California is so low. You don't want the stress of having to take that exam and wait 4 months to see if you are among the lucky 40% who passed it. Register as an in-house counsel, pay your fees, pass the character examination, do your CLE, and count yourself lucky that you can practice law in California legally and without having to sit for the California bar. Once you are registered as an in-house lawyer in California, does that mean you can do everything a California lawyer can do? As we lawyers love to say, no. But you can do pretty much everything you need to do as an in-house lawyer, which is the whole point. California Rule of Court 9.46 imposes 2 limitations on registered in-house counsel, but it also bestows one very important benefit. The first limitation is that you may only represent your employer, including its subsidiaries and affiliates under the company's control, and you may not represent any individuals. Generally, this should not present a problem for in-house lawyers because in nearly all cases, your client is the company and not any individual employee, officer, or director of the company. In rare cases where an in-house lawyer might represent an individual, that is not permitted if you are an out-of-state lawyer working as an in-house lawyer in California under the authority of Rule 9.46. The second limitation is that in-house lawyers can't make any court appearances. So if you are a litigator or a general counsel who would like to appear in court, you would have to go through the formal pro hac vice process, which may or may not be available to you or may not be a practical solution for in-house counsel due to the separate requirements that practice imposes. For example, in California, you may not apply for admission pro hac vice if you are a resident of California, are regularly employed in California, or engaged in substantial business, professional, or other activities in California. Bottom line, if you are an in-house litigator who seeks to take an active role in litigation, Rule 9.46 may not provide enough flexibility for you, and you may need to become a member of the California Bar in order to practice effectively. These 2 limitations, however, are generally outweighed by one huge benefit. Registered in-house counsel can practice indefinitely in California under Rule 9.46. While you must renew your registration annually, fulfill your CLE requirements, and pay your fees, you can spend your entire career practicing as an in-house lawyer in California without ever having to sit for its truly awful bar exam. What if you're looking to go the other way? You're admitted in California but want to register as an in-house lawyer in New York. What are your requirements in that case? New York's Rule of Court 522.1, which governs the registration of in-house lawyers in New York, generally requires the same things and provides the same benefits to in-house lawyers as California's rules do, with just a few differences. New York allows foreign lawyers, that is, lawyers who are admitted in another country such as Canada or the United Kingdom, to register as in-house counsel, whereas California permits such lawyers only to register as foreign legal consultants. Foreign legal consultants are limited to giving advice relating only to the laws of their home jurisdiction and not to the law of the U.S. or any U.S. state, versus registered in-house counsel in New York or California, who can give advice on the law of any U.S. state or federal law. New York also allows in-house counsel to represent individuals as long as they are employees, officers, or directors of the lawyer's employer, and as long as the representation is in connection with matters relating to the lawyer's work for the employer. In other words, the in-house lawyer can advise an employee on matters relating to his or her work at the company, but not any personal matters. So in general, while New York requires registration, passing a character examination, CLE, and payment of some fees, it likewise allows in-house counsel to avoid taking the bar exam and to practice indefinitely, plus a few additional things that registered in-house lawyers in California cannot do, such as represent company officers, directors, or employees as individuals. But wait, you say, doesn't ABA Model Rule 5.5 have a Part D that specifically talks about in-house counsel? When are you going to get to that? The answer to that is right now. To remind you, ABA Model Rule 5.5D states that a lawyer admitted in another United States jurisdiction or in a foreign jurisdiction and not disbarred or suspended from practice in any jurisdiction or the equivalent thereof, or a person otherwise lawfully practicing as an in-house counsel under the laws of a foreign jurisdiction, may provide legal services through an office or other systematic and continuous presence in this jurisdiction that 1. Are provided to the lawyer's employer or its organizational affiliates, are not services for which the forum requires pro hac vice admission, and when performed by a foreign lawyer and requires advice on the law of this or another U.S. jurisdiction or of the United States, such advice shall be based upon the advice of a lawyer who is duly licensed and authorized by the jurisdiction to provide such advice. Or 2, are services that the lawyer is authorized by federal or other law or rule to provide in this jurisdiction. What this says is that a lawyer admitted in another state, including in a foreign jurisdiction like Canada or the United Kingdom, and not disbarred in any jurisdiction, may provide legal services in this state that are provided to the lawyer's employer or its affiliates, as long as they are not services for which the forum requires pro hac vice admission. The reason I didn't start with ABA Model Rule 5.5D is that, as we saw with California and New York, while both states have enacted rules similar to ABA Model Rule 5.5D, the differences are significant enough that you need to learn those rules instead of relying on ABA Model Rule 5.5D. ABA Model Rule 5.5D doesn't require registration, but California and New York both do, and in the case of California, registration within the first 6 months, or else your application could be denied on that basis alone. For an example that goes the other way, Texas is one of the 2 states that has not adopted a rule similar to ABA Model Rule 5.5D. But Texas actually gets to the same result different means. The Texas Board of Law Examiners has issued a policy statement that in-house counsel are not required to be licensed in Texas as long as they are licensed and in good standing in another state and are in-house counsel. So, while Texas does not have a Rule 5.5D, in-house lawyers can practice in Texas as long as they meet the same requirements as ABA Model Rule 5.5D. The takeaway here is that if you are an in-house lawyer seeking to take advantage of ABA Model Rule 5.5D, you need to look at your state's version of ABA Model Rule 5.5D to see what it requires, even if you live in a state that has enacted a rule similar to ABA Model Rule 5.5D. As we saw earlier, both California and New York allow in-house counsel to practice, but each piles on a few more requirements and imposes a few more restrictions that are not present in ABA Model Rule 5.5D if you want to practice in the Golden or Empire states, respectively. The second key piece of advice for lawyers to help you avoid the unauthorized practice of law is that there is no such thing as a free lunch. Being able to practice as a lawyer outside your home state does not come without a price, and I'm not talking about the state bar fees you may have to pay or the CLE requirements you may have to satisfy. I'm talking about the fact that practicing law outside your home state makes you subject to the ethics rules and the disciplinary authority of the state where you are practicing, in addition to the ethics rules and disciplinary authority of your home state. This is covered by ABA Model Rule 8.5, and it is almost universally followed without modification or exception by all 48 states and the District of Columbia that have adopted ABA Model Rule 8.5 or similar rules. The first part of ABA Model Rule 8.5 provides that A. Disciplinary authority. A lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. A lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in this jurisdiction. A lawyer may be subject to the disciplinary authority of both this jurisdiction and another jurisdiction for the same conduct. Let's unpack this section of the rule in some detail. First, ABA Model Rule 8.5 provides that a lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. So, if you are a California lawyer, you are always subject to the disciplinary authority of California, even when you are performing temporary legal services in another state pursuant to the authority granted by ABA Model Rule 5.5, or if you are an in-house counsel registered to practice in New York under New York Rule of Court 522.1. Put another way, you can never escape the disciplinary authority of the state or states in which you are a member of the bar. Second, ABA Model Rule 8.5 provides that a lawyer is now also subject to the authority and jurisdiction of the state bar in the state or states where your practice of law occurs. For example, a California lawyer performing temporary legal services in New York for a New York client under ABA Model Rule 5.5c1 is now expressly subject to the jurisdiction and disciplinary authority of the New York State Bar, in addition to the disciplinary authority of California. ABA Model Rule 8.5 now grants each state the authority to discipline a lawyer who is not admitted in that state, and you are bound by that rule in nearly all of the states and the District of Columbia that have adopted ABA Model Rule 8.5 verbatim, or a rule similar to ABA Model Rule 8.5. As a bright lawyer, I'm sure you already have anticipated my next point, which is, if I can be subject to two or more states' ethics rules, and because the ethics rules can vary in material respects state to state, doesn't this raise the possibility of conflicts? The answer to that is a resounding yes, and ABA Model Rule 8.5 itself attempts to resolve certain of those potential conflicts with Section B entitled Choice of Law. Here is what the rule says: Choice of law. In any exercise of the disciplinary authority of this jurisdiction, the rules of professional conduct to be applied shall be as follows. 1. For conduct in connection with a matter pending before a tribunal, the rules of the jurisdiction in which the tribunal sits, unless the rules of the tribunal provide otherwise. And 2. For any other conduct, the rules of the jurisdiction in which the lawyer's conduct occurred, or, if the predominant effect of the conduct is in a different jurisdiction, the rules of that jurisdiction shall be applied to the conduct. A lawyer shall not be subject to discipline if the lawyer's conduct conforms to the rules of a jurisdiction in which the lawyer reasonably believes the predominant effect of the lawyer's conduct will occur. Let's break this part down. First, if a lawyer's conduct is in connection with a matter pending before a tribunal, it is the rules of the jurisdiction in which the tribunal sits that will govern. So, if you are an in-house litigator representing a client in connection with a lawsuit pending in the U.S. District Court for the Southern District of New York, it is the rules of that court and the legal ethics rules of the state of New York that will govern your conduct. Second, for all other conduct, it is the rules of the jurisdiction in which the lawyer's conduct occurred, or if the predominant effect of the conduct is in a different jurisdiction, the rules of that jurisdiction that will govern. So, the standard here is where the lawyer's conduct occurred or where it had its predominant effect, which is similar to the test for exercising personal jurisdiction over a defendant in a tort action that is familiar to many lawyers. That said, parties litigate all the time over where tortious conduct occurred versus where it has its predominant effect. So this test, while familiar, may not yield a clear result in all cases. The good news is that ABA Model Rule 8.5b2 also includes a safe harbor, which is, a lawyer shall not be subject to discipline if the lawyer's conduct conforms to the rules of a jurisdiction in which the lawyer reasonably believes the predominant effect of the lawyer's conduct will occur. So if you make a reasonable mistake about which jurisdiction's law should apply to your conduct, but you conformed your conduct to the ethics rules of that state, You cannot be disciplined for having picked the wrong state. My third key piece of advice for lawyers to help you avoid the unauthorized practice of law is litigators beware. As a former law firm and in-house litigator, I can tell you that litigators aren't afraid of much, but we should be afraid, very afraid, when it comes to multi-jurisdictional practice because this area is full of traps waiting to ensnare litigators. Let me start with a simple case that has a clear, albeit not easy, fix. If you are a litigator and you are not admitted to practice in the state where you work, you need to become a member of that state's bar. Now, I am not talking about remote work. We get to that topic soon. Setting remote work aside, there is very little that a litigator can do in his or her home state that doesn't require membership in that state's bar. For example, in California, you can't appear in court or attend a deposition if you are not admitted in California. While you could do both things if you were admitted pro hac vice in the matter, California prohibits lawyers who live or work in California from seeking pro hac vice admission in California state courts. You can't appear or attend a deposition in a case that is pending in California federal court either, as you cannot become a member of those courts unless you are a member of the California bar. If you are a litigator, my strong advice to you is to become a member of the bar in the state where you live and practice, because whatever you are probably doing right now involves the unauthorized practice of law in that state. This may sound like tough love, but if you remember the various consequences that can flow from an unauthorized practice of law finding, reputational, financial, legal, and ethical, you will end up thanking me. For most litigators, they are admitted in their home states, but often are called upon to perform legal work and give advice in connection with litigation matters arising or pending in states where they are not admitted. In typical lawyer fashion, the answer on what to do in these cases is it depends, and we will spend the next few minutes reviewing the ethics rules and walking through a couple of examples. We already reviewed ABA Model Rule 5.5, which affords all lawyers, including litigators, some latitude to practice law temporarily in another state. If you are planning to participate in a litigation matter in a state that has adopted ABA Model Rule 5.5 verbatim, that would be the place to start. But as we saw before, certain states like California and New York have different requirements and impose different restrictions on litigators seeking to practice law in their states, so you need to check those states' rules and not simply rely on ABA Model Rule 5.5. Let's start with California and what it requires of and allows litigators to do in connection with litigation matters arising or pending in California. California Rule of Court 9.47 governs what out-of-state litigators can and can't do in California. Rule 9.47 contains two preliminary requirements. One is easy to satisfy and one that could give litigators a problem. The easy requirement for out-of-state litigators is that you must be a member in good standing of your state's bar. You are not going to get very far in multi-jurisdictional practice if you are disbarred or suspended in your home state. Second, and this is the requirement that could be more problematic, you must have an office outside California and you must not have a California residence or substantial business in California. The idea is that you don't want lawyers who live in California and have their office in California taking advantage of a rule for out-of-state lawyers. As I said before, if you are a litigator living and working in California, and once again setting aside remote work, you are a California lawyer and you need to be admitted in California. If, on the other hand, you live in New York and your office is in New York, and you don't have any offices in California, and you happen, from time to time, to represent your company on litigation matters that arise in California, Rule 9.47 will allow that. Finally, although Rule 9.47 for litigators, unlike Rule 9.46 for in-house counsel, does not require you to register with the State Bar of California, you should recognize that by practicing law in California pursuant to Rule 9.47, you are subjecting yourself to the disciplinary authority of the California State Bar, in addition to the disciplinary authority of your home state pursuant to ABA Model Rule 8.5. Apart from these general requirements, Rule 9.47 includes another specific limitation for litigators. Your legal services must be performed in anticipation of filing a lawsuit in California or in a state in which you reasonably expect to be entitled to appear, That is, a state where you are admitted to the bar, or a court, where you expect to be granted leave to appear pro hac vice, or part of a lawsuit already pending in a state in which you are entitled to appear. In cases where the lawsuit in California is pending, authorization to perform legal services ends when that lawsuit is filed, after which you are required to seek pro hac vice admission in order to continue to participate in that case. The idea here is that if there's pre-litigation going on in California, and you expect that a lawsuit will be filed in California, or there's an existing lawsuit in your home state of New York, that you'd be allowed under Rule 9.47 to participate in settlement negotiations or attend a deposition in California. However, once a case is filed in California, Rule 9.47 requires you to seek pro hac vice admission so as not to supplant the existing pro hac vice system and requirements. So if you're actively going to participate in a lawsuit that's been filed in California, you do have to go through the normal pro hac vice admission process, and Rule 9.47 is not a substitute for that. This is one area of the ethics rules where lawyers doing transactional work have it much better than litigators. In California, as long as you meet the requirements of good standing in another state and no office, residence, or substantial business in California, California Rule of Court 9.48 gives lawyers broad latitude to perform legal work and give legal advice in connection with transactional and non-litigation matters as long as a material aspect of the transaction or other matter takes place in your state, or the advice relates to an issue of federal law or the law of a state other than California. In other words, Rule 9.48 affords transactional lawyers broad license to provide legal advice to your clients in that it applies to anything non-litigation and can include advice on California law as long as a material aspect of the matter relates to your own state or relates to other states or federal law, which is a pretty easy standard to meet as long as we are talking about a reasonably complicated transaction or other matter. Let's turn our attention now to litigators seeking to practice in the Empire State. Unlike California, New York has a rule of court that more closely tracks ABA Model Rule 5.5, which is Rule 523, and if you are in compliance with ABA Model Rule 5.5, you will be in compliance with New York's Rule 523. Here are 3 key points to keep in mind about New York's Rule 523. First, New York does allow out-of-state lawyers to associate with a New York lawyer who actively participates in and assumes joint responsibility for the matter for the purpose of performing temporary legal services in New York. This could be useful for litigators seeking to perform legal work for their client on a matter arising in New York, although it would require them to associate with another lawyer who is admitted in New York. Second, New York allows out-of-state litigators to participate in a mediation, arbitration, or other ADR process, and unless that process is being conducted in connection with a New York lawsuit, no pro hac vice admission is required. As we know, the vast majority of litigation matters are settled, and being able to participate in ADR proceedings, particularly where ADR is mandatory, can provide litigators with the authorization they need in a large number of cases. Third, like California, an ABA model, Rule 5.5, practicing law in New York pursuant to Rule 523, subjects you to the disciplinary authority of the New York State Bar, in addition to the disciplinary authority of your home state pursuant to ABA Model Rule 8.5. For our final topic, we are going to cover off the question of remote or hybrid work. During the COVID-19 pandemic, when the world was shut down for a matter of many weeks and in some states for a matter of many months, like everyone else who was able to do so, lawyers were forced to work remotely. Some of those lawyers took the opportunity to relocate to another state and to work remotely from that location. Think of a lawyer who works at a law firm in New York who was licensed in New York and represents clients in New York moving to Florida during the pandemic and working remotely from that location. As the pandemic receded and workplaces began to reopen, like many others, lawyers continued to work remotely or in some cases, to employ a hybrid strategy, spending some number of days physically located in the office and some number of days working remotely from home. This raised the question whether a lawyer, as in our hypothetical who moved to Florida but continued to practice law in New York remotely, was engaging in the unauthorized practice of law in the remote state, in this case, Florida. To be clear, this is the opposite case from the one we have been considering in today's presentation. Up until now, we have been thinking about a lawyer who lives in New York and is licensed in New York and is being asked to perform legal work for clients located in another state, such as Florida, where the lawyer is not admitted. Remote and hybrid work is where the lawyer is living in Florida but is not performing legal work for clients in Florida, but instead, the lawyer is continuing to perform his or her legal work exclusively for clients located in New York, where the lawyer is a member of the bar. Thankfully, in December 2020, the ABA Standing Committee on Ethics and Professional Responsibility stepped in to provide timely guidance on remote or hybrid work by issuing Formal Ethics Opinion Number 495. That opinion stated that lawyers may remotely practice the law of the jurisdictions in which they are licensed, while physically present in a jurisdiction in which they are not admitted if the local jurisdiction has not determined that the conduct is the unlicensed or unauthorized practice of law, and if they do not hold themselves out as being licensed to practice in the local jurisdiction, do not advertise or otherwise hold out as having an office in the local jurisdiction, and do not provide or offer to provide legal services in the local jurisdiction. Because the ABA does not have the authority to opine on state unauthorized practice of law statutes, it had to defer to the states on that key issue, but at the same time, its opinion that remote work should be allowed stood to carry great weight when the states took up that question. So as applied to our hypothetical, the ABA has opined that a New York lawyer practicing law remotely from Florida would not be violating ABA Model Rule 5.5a as long as Florida doesn't consider remote work to constitute the unauthorized practice of law under Florida law. The lawyer also must not hold himself or herself out as being licensed to practice in Florida, advertise or otherwise hold out as having an office in Florida, or provide or offer legal services to clients in Florida. As we saw in our discussion earlier today, these are the same basic rules that all lawyers must follow with regard to jurisdictions in which they are not licensed, so those same requirements would not be a barrier to remote or hybrid work. In the wake of Formal Opinion Number 495, nearly 30 states and the District of Columbia, including each of the top 5 states that have the most practicing lawyers, which are New York, Maryland, Massachusetts, Connecticut, and Illinois, plus other common remote work destinations such as Florida and California, have followed the ABA's lead by confirming that remote work by lawyers in their states does not constitute the unauthorized practice of law, as long as the lawyers follow the basic rules outlined above. In light of the determinations by these key states, you are very likely on safe ground if you are working remotely in a state where you are not admitted, as long as you are not holding yourself out as being licensed to practice in the remote state, advertising, or otherwise holding out as having an office in the remote state, or offering legal services to clients in the remote state. This brings us very close to the end of today's program, and also to my final key piece of advice for lawyers to help you avoid the unauthorized practice of law. Look before you leap. While I've given you some guidance today that should help you understand the legal ethics rules that govern multi-jurisdictional practice, and made you aware of several traps for the unwary lurking in these rules, you need to look carefully at the ethics rules that apply in the state or states that are at issue for you before leaping into performing legal work in any of those states. To prove my point, let's say you are an in-house lawyer in New York who wants to give legal advice to your company in connection with a litigation matter that has been filed against your company in California State Court. Having listened to today's presentation, you know that you can only perform temporary legal services in California, and that even those temporary services impose certain limitations on what you can and cannot do, particularly when litigation matters are involved. In light of this, you decide to associate with another in-house lawyer at your company who is admitted in California, who will assume primary responsibility for the matter just to be safe. Is this a good idea? No, in fact, it is a really bad idea. California has no equivalent of ABA Model Rule 5.5c1, which is the provision that gives out-of-state lawyers the option to associate with a local lawyer. The only basis on which an out-of-state lawyer can legally practice law in California in our hypothetical are the ones set out in Rule 9.46 for registered in-house counsel and Rule 9.47 for litigators. If your representation doesn't fall into one of these categories, or if you don't meet the requirements of that category, you are engaged in the unauthorized practice of law in California. Worse still, your in-house colleague who is associating with you would be violating the ethics rules by aiding and abetting you in the unauthorized practice of law in California. So, by taking what seems like a reasonable and cautious approach to a problem, but without having taken the time to study the California rules carefully, you easily could subject yourself, your colleague, and your company to the reputational, financial, legal, and ethical consequences for having engaged in the unauthorized practice of law. In yet another example, if you are licensed to practice law in New York, but you are now working remotely in Missouri, a state which has adopted a version of ABA Model Rules 5.5 and 8.5, you might be tempted to think you are in the clear, but an advisory committee of the Missouri Supreme Court recently issued an informal opinion that performing any legal work in Missouri by a lawyer who is not a member of the Missouri Bar would constitute unauthorized practice of law in Missouri. This guidance from Missouri runs contrary to the clear trend among the states, but if you are a lawyer in Missouri, it is key guidance that you need to follow, so it makes sense to do the research on your particular state and situation before you act whenever multi-jurisdictional practice is involved. In closing, whenever multi-jurisdictional practice is involved, always remember, when in doubt, register. There is no such thing as a free lunch. Litigators beware, and look before you leap. Let's be careful out there. Thanks for joining me.